In this subunit, we're going to discuss two formation defenses, incapacity and undue influence. All right, so let's review. These are our defenses. We've already talked about duress and misrepresentation. Later in this unit, we'll talk about illegality, public policy, and unconscionability. In this subunit, we're going to focus on the defense of incapacity, lacking legal capacity to enter into a contract, and undue influence. Let's set up the defense of incapacity with just a couple simple fact patterns, right? So the first one is minority. Let's say that someone enters into a contract with a 15-year-old and sells a motorcycle to a 15-year-old. And the other is someone suffering from some sort of mental disability or mental defect or mental infirmity. So say, for example, someone purchases a house from someone suffering from dementia. All right, let's talk about the law of incapacity when one of the parties is a minor. In most jurisdictions, you're a minor if you're under 18 years of age. Sometimes courts will call this person an infant, even though we would never think of a teenager as an infant. When a court says an infant, we just understand that it means someone under 18 years of age. The law is pretty simple that if we have a completely executory contract, meaning neither of the parties has performed under the contract, then the contract is voidable at the election of the minor. Things become a little bit more complicated when either of the parties has already fully performed or partially performed. Does the other party have to give back the consideration when the minor voids the contract? So does the other party have to give back the consideration? Does the minor have to give back the consideration? Let's explore that a little bit further. Okay, let's look at the situation where we have either full performance or partial performance by either party in a contract with a minor. So the question is, does either of the parties have to return the consideration they received in the transaction when the minor voids the contract, right? Just so you know, this is not a cause of action in contract when you're asking the other party to return the consideration. It is a cause in restitution or unjust enrichment or quasi-contract. In other words, we no longer have a contract, but I've already performed and given you consideration. Please return that consideration or else you will be unjustly enriched. Okay, so when the minor has already performed, let's say the minor has paid, and now the minor voids the contract, what are the obligations of the other party to return the consideration she has received? Well, generally courts are saying that the other party must return whatever consideration she received from the minor. You have to return it all. In some circumstances, courts will say the other party only has to return the consideration less depreciation and use of the goods if the minor has taken the goods and used them. What does the minor have to do? Well, the minor has to return the consideration that she received and has kept in whatever condition it is now. Other courts might say that the minor has to return the consideration received, and if she has sold that, then the proceeds of that sale, if the proceeds are traceable. So let's just look at an example. Let's imagine we have a party who is selling a motorcycle to a minor for $2,000. So let's say the transaction has occurred. The other party has delivered the motorcycle. The seller has delivered the motorcycle to the minor, and the minor has paid the $2,000. So the minor now voids the contract, as is her option. What are the party's obligations in restitution? Well, first let's talk about the other party. So if the court takes the first approach where the other party has to return any consideration she has received, that means here in this case the seller has to return the $2,000, all of it, to the minor. If the court takes the other approach, then the seller, the other party, will have to return the $2,000 less any depreciation on the motorcycle, the wear and tear that was caused by the minor's use of the motorcycle. So $2,000 less whatever depreciation the motorcycle suffered. What must the minor do in restitution? Well, the minor must return the motorcycle in most jurisdictions. Just return the motorcycle in whatever condition it is now. Or in some jurisdictions, the minor must return the motorcycle. And if she has sold the motorcycle, she has to then provide the seller with the cash proceeds of that resale, assuming the cash proceeds are fairly traceable to the sale of the motorcycle. You might say, well, there are a couple options there. When will a court use one or the other? Well, the simple answer is it depends on jurisdictions, but it also might depend on the facts. So if the minor is using the doctrine of incapacity as a sword, she is suing to get her money back, the court might be a little less willing to completely protect the minor. In that case, you might see a court say, well, the other party returns the consideration less any wear and tear. Or the court might say, well, the minor has to return the motorcycle or any proceeds from the sale of the motorcycle. If the other party, in this case the seller, has engaged in any kind of overreaching, has taken advantage of the minor, the court is much more likely to fully protect the minor and just say the minor just has to return the motorcycle in whatever condition it is in, and the other party, the seller in this case, has to return the complete proceeds that she received from the minor, the consideration she received from the minor. In this case, $2,000. All right, continuing on with our discussion of incapacity when one of the parties to the contract is a minor. There are some exceptions to the ability of the minor to void the contract. The first exception is necessaries. You can also call it necessities if that makes more sense to you. There's the case of the emancipated minor, and then there are statutory exceptions. So necessaries, if you provide food, shelter, or clothing to a minor, something the minor needs, then you can recover from the minor, but not under contract. You can recover from the minor under quasi-contract. So food, shelter, and clothing seem to be necessaries. There might be other things in a modern society, maybe a cell phone, maybe a car, right? Maybe not a luxury car is not a necessary. So it's really fact dependent. The second exception is the emancipated minor. And so a married minor might be considered an emancipated minor. So for example, if you have a minor and she is married or he is married and now her responsibilities are to take care of a family, if you say that this minor can engage or enter into enforceable contracts, you're effectively cutting off this minor's ability to get the things she needs. So we have an exception for married minors and emancipated minors. Emancipated minor is something a little bit different. That's where a minor actually goes to a court and sues to be emancipated from his or her parents. Sometimes you'll hear about famous movie stars doing this. I think Macaulay Culkin did this, that he had the court declare him an emancipated minor. If you're an emancipated minor, then you can enter into contracts on your own behalf, and they are not voidable. You may not avoid them. And then there are certain statutory exceptions, some banking laws, some military laws, and educational loans. When I was 17, I signed a contract. I joined the Army and I signed a contract. And I was only 17, I was a minor, but it was binding because the law made an exception to the general common law rule that a minor can void a contract. All right, finishing up our discussion of incapacity because of minority, let's talk about affirmation. We've talked about this idea before. In this case, when after the minor reaches the age of majority, she can affirm or ratify the contract. And she can do that expressly by saying, hey, this is a good deal for me. I affirm this contract. I ratify this contract. or she can do it implicitly. So if after a reasonable time of her reaching majority, she does not disaffirm the contract and she keeps the benefit of the contract, she has implicitly ratified or affirmed that contract, and she loses her defense of minority or incapacity. Let's talk about incapacity because of mental infirmity or mental defect. There's a lot of ways that this is articulated: mental affliction, mental defect, mental illness, cognitive disability. Doesn't matter whether it's permanent or temporary. If the person was suffering from it at the time she entered into the contract, then the contract is voidable by that person. Let's look at the details, however. All right, there are two tests. The first is the cognitive test, and the second is what is called the motivational test. The cognitive test is because of mental illness or defect, she was unable to understand what she was doing when she assented to a contract. So, for example, when she signs the contract, she thinks she's a movie star signing an autograph. The second test is a little bit different. The second test is where the person understands she's entering into a contract, but because of mental illness or defect, she cannot act in a reasonable manner with respect to the transaction, and the other party has reason to know. So in this case, we're going to protect the person suffering from the mental defect, but we're also going to give some protection to the other party. And unless she knew or had reason to know, unless the other party knew or had reason to know, we're going to provide that party with some protection too. So here's an example. She understands she's signing a contract, but she thinks she needs 5 cell phones in case there is a world shortage of cell phones because of the zombie apocalypse or something like that, right? Once again, that's just one side of the story. We also have to ask, but did the seller know or have reason to know that the other party was operating under some mental disability that made her unable to deal with this transaction in a reasonable manner? All right. What about the situation where a person is suffering from mental impairment because of drugs or alcohol? You probably understand that we're going to give this person a little bit less protection than we do the person who is suffering from a cognitive defect and can't understand what she's doing at all because she was born with this or because she suffered some sort of accident, right? If you're using drugs or alcohol, this condition is kind of self-inflicted. So the rule is that we will protect the party that is impaired because of drugs or alcohol and enters into a contract because either she doesn't know what she's doing or she can't deal with the transaction in a reasonable manner. But once again, we're going to look at the other party. Did the other party have reason to know that the contracting party, the party she's contracting with, could not deal with this situation in a reasonable manner because she was impaired by drugs or alcohol, or just simply didn't understand what she was doing? Okay, moving on. Affirmation. Just like we saw in duress, misrepresentation, incapacity. After the mental disability, mental affliction, cognitive disability, whatever, after it's gone, the party can ratify the contract. And the party can do that expressly or implicitly, just like we've seen before. Our last topic in this subunit is undue influence. Let's jump right into the law of undue influence. An aggrieved party can void the contract if there's a relationship of trust or dominance with the other party engages in unfair persuasion. This induces the aggrieved party to assent to the contract, and the contract is unfair. Just like we've seen in misrepresentation, undue influence, duress, incapacity, once the reason for the defense is gone, is no longer there, the party can affirm the contract. It's the same here for undue influence. The party can affirm or ratify the contract either expressly or implicitly. The elements of undue influence that are the most important are the relationship of trust and dominance and unfair persuasion. Let's look at those one by one. All right, so we're talking about undue influence, and the first element of undue influence is that there is a relationship of trust or dominance between the parties. So here are some examples of relationships of trust: parent-child, husband-wife, clergy-parishioner, etc. When you answer a question or when you see this in a fact pattern, you should be able to articulate whether this is a relationship of trust or dominance, or maybe both. Here are some examples of relationships of dominance: supervisor, subordinate, employer, employee, a caregiver, and a shut-in. Once again, this is very fact specific. It doesn't mean that in every employer-employee relationship that it's a relationship of dominance, but it could be. It could be. So keep your eyes open for those fact patterns. The next element in undue influence is that there is unfair persuasion. So the other party, the party in the dominant position or the party that is trusted, engages in unfair persuasion against the aggrieved party, right? So there are lots of different facts to look for, so they don't give them enough time to consider it. They insist. They engage in dishonesty or subterfuge. That doesn't rise to the level of misrepresentation, but it's dishonesty. There's intimidation, possibly, that doesn't rise to the level of duress. It's not a threat, but there is intimidation there. So what I'm looking for in a fact pattern is some fact pattern that doesn't quite fit in to the strict rules of misrepresentation, where there has to be a statement not in accord with the facts, or duress, where there has to be a threat. But in this case, undue influence, we have a relationship of trust or dominance, and therefore we don't have to have a threat, and we don't have to have a strict misrepresentation. But if we do have intimidation, we do have unfair persuasion in the form of pressure, or we do have dishonesty, which isn't quite misrepresentation, then maybe a court will provide the aggrieved party with some protection. All right, we're talking about undue influence, and we've already talked about the two most important elements of the rule: the relationship of trust or dominance and unfair persuasion. The other two elements are that it induces the party to assent. We've discussed this element enough in the past to give you a good idea of what you're looking for here, what to look for in a fact pattern that will indicate that the aggrieved party assented to this contract because of the relationship of trust or dominance and the unfair persuasion of the other party. And the final element is that it has to result in an unfair agreement. It's hard to put your finger on what things make up an unfair agreement, but look for something that's just so one-sided that it would shock the conscience of a court.